All right, we are going to get started. It is 2:01. All right, welcome everybody. Good afternoon or good morning, depending on where you are, and happy Friday. Thank you for joining us today for our most recent webinar. I'm Tina Barr, the Director of Training and Education for the National Association for Civilian Oversight of Law Enforcement. NACOLE is an organization that works to create a community of support for independent civilian oversight entities seeking to make their local law enforcement agencies, jails, and prisons more transparent, accountable, and responsive to the communities they serve. One part of that effort is our webinar series. Since 2015, NACOLE has worked to bring you information on effective practices in civilian oversight, innovations in the field, and efforts to reform the criminal legal system through the webinar series. So before we begin today, I'd like to go over a few logistics. First, you have the ability to turn on your captions for this webinar by using the caption button at the bottom of your screen. Next, everyone has entered the webinar in listen-only mode. The chat feature is disabled. However, the Q&A feature is on, so please feel free to post your questions that you have in the Q&A feature. To ensure that the speakers today cover all of the information that they've prepared for you, they'll respond to questions at the end of the presentation. Everyone will have the ability to upvote questions by clicking the thumbs up icon beside a particular question. Upvoting moves questions up in the queue, which will help us to address some of the most pressing questions after the presentation. To allow more time for questions and direct engagement with our speakers, immediately after the webinar, we will have a 30-minute discussion. The discussion will take place in a different Zoom meeting room, and I will provide the link to that meeting room the closer it gets to the end of the prepared remarks, closer to the end of the hour. So if you're interested in joining us for that discussion, please be on the lookout for that, and I will be as clear as possible about how to join that discussion. So finally, today's webinar is being recorded and will be available to only those who have registered for the webinar for 3 months. You'll receive an email within 5 business days of today with information on how to access the recording, as well as a PDF version of the webinar slides that the speakers are using today. So moving on to today's webinar, addressing key issues in law enforcement youth interactions. For the sake of time, I'm going to give an abbreviated description of the webinar and also an abbreviated description of each of the speakers. The full description of the webinar, as well as the full bios for our speakers, are on our website. Our speakers today will describe key legal precedent and social science research supporting the need for law enforcement agencies and officers to treat youth differently than they would adults. They will introduce their organization's recently developed model policies on police-youth interactions and discuss how these policies can be a tool for civilian oversight boards and practitioners. Our speakers today are with Strategies for Youth, a national nonprofit training and policy organization dedicated to ensuring best outcomes for youth interacting with law enforcement. Lisa Thurau, an attorney, is the founder and executive director for Strategies for Youth. She founded the organization in 2010 with the goal of ensuring that officers are equipped with both training and policies based on using developmentally appropriate, trauma-informed, equitable approaches with youth. Lisa has been consulted by state legislators, state agencies, the U.S. Department of Justice, and the U.S. Department of Education on policing's impacts on youth, as well as policy development, statutory reforms, and developmentally appropriate, trauma-informed, equitable law enforcement policies. Shelley Jackson is Strategies for Youth's law enforcement policies attorney. She has more than 30 years of experience protecting the civil rights of youth, people with disabilities, and other vulnerable populations. Prior to her retirement from federal service in 2020, Shelley worked for 3 federal civil rights agencies as an attorney, policy analyst, and supervisor, including nearly 10 years as a deputy section chief in the Civil Rights Division of the U.S. Department of Justice. She joined Strategies for Youth in 2022 to work with Lisa to develop the organization's model law enforcement policies for youth interaction, which they will highlight today. So without further ado, I would like to turn things over to Lisa and Shelley.
Thank you very much, Tina, and thank you to NACOLE for inviting us to present this webinar. We're grateful for this opportunity, and we hope you'll leave this webinar thinking of some things to ask about the law enforcement agencies you partner with. A roadmap for today's discussion includes first an introduction to the work of strategies for youth and why we think youth-based policing and policies are necessary in distinction to adult ones. We're going to look a little bit at the role of civilian oversight and then take a closer look, led by Shelley, at 3 typical interactions and how our model policies can help address them in a way that ensures good outcomes and constitutional protections are met for youth. Finally, we're going to make sure that you have repeated access and frequent access to our policies as a resource for your work as civilian members of oversight agencies, of law enforcement agencies. I'll begin by describing our mission. We are a national nonprofit policy and training organization dedicated to ensuring the best outcomes for youth who interact with law enforcement. And we do this in a number of ways. As Tina said, we make sure law enforcement officers have training that is based on developmentally appropriate, trauma-informed, equitable policies, approaches, and understanding. And we create our policies on those same principles. In addition, we do something called Juvenile Justice Jeopardy, which is an outreach and engagement tool for young people to prepare them for interactions with police and their peers out in the field and to reduce their legal jeopardy. We strongly believe, and it's our mission, to reduce formal system involvement of youth. We believe it is the least desirable outcome for youth. And youth arrests and legal system involvement may be necessary, but we strongly believe it should be a last result. That's because negative encounters with law enforcement have a lasting negative impact on youth. And those can include emotional distress, adverse health outcomes, and recidivism. Youth are also not always deterred by a punishment approach, especially if they view it as unfair or immoral. And often that approach will actually, again, lead to some outcomes that are not at all anticipated or the goal of such punishment. Finally, because punishment has been so clearly understood to be limited, we believe that alternative interventions may be more effective and should be considered more frequently. Our mission as a result of those views is to go upstream and to work with gatekeepers such as law enforcement to avoid arrests, escalation of incidents, and use of force, and to equip law enforcement officers as well as law enforcement agencies to use developmentally appropriate practices, and finally to educate youth. Our objectives for law enforcement are basically and broadly explained as making sure that we can equip them with the developmental competence they may need to have unescalated and avoid escalation of incidents with youth, dig deeper, understand what behavior may be hiding or reflecting, and again, make sure it is appropriate to the age of the youth they're dealing with. And when we talk about being trauma-informed, we want officers in particular to realize as gatekeepers that it is often trauma that brings youth into their orbit, and that sometimes youth perceive officers as a source of trauma. Children, a recent case about 14 years ago said what we know, which is that children cannot be viewed simply as miniature adults. This is the case of JDB versus North Carolina. And we could not agree more. It is something that's not new to the Supreme Court. A decision in 1948 recognized this too, but it keeps needing to be repeated. And it's necessary for folks to remember that teen brains are still developing. They may look like adults, but that doesn't mean they think or can act like adults. The teen brain is under construction, and it's not clear when it starts. It's generally more clear when it ends, and it's supposed to end somewhere between 25 to 28 years of age. But that depends a lot on some of the experiences youth have had, the level of trauma, the level of toxic stress, and other factors. We know that this age group is very reactive. It does not think before it acts. It thinks sometimes after it acts. And finally, we know that it's an age group that is very certain it knows the right answer, but is actually quite uninformed. And if there are any law enforcement officers on this call, I'm sure they can tell you examples of youth asserting their rights in language that has nothing to do with any of the amendments, much less laws that guarantee those rights. So this is not an easy age group to police. It's not easy to be a teen or have your brain in development and leading to so many ups and downs. And therefore, we're strongly in earnest trying to ensure that law enforcement officers are adequately equipped to deal with this age group. But they're not, and they're often ill-equipped. In spite of what science and the U.S. Supreme Court recognize about how youth are different from adults, most law enforcement agencies do not have policies that distinguish youth from adults, and most states do not require youth-specific training or policies in their posts or peace officer standards and training commissions. And that's unfortunate because teen brains and untrained officers using adult policies equal too many bad outcomes. Just as an example, you see routinely encounters that escalate from officers who don't have the predilection to understand how to avoid that or haven't been trained and don't have policies. We see unreasonable stops and searches that violate the Constitution, as well as basic rights that youth should be able to enjoy. We see unnecessary arrests, sometimes called contempt of cop arrests or arrests used to teach youth a lesson. And we see unreasonable and excessive use of force in some very disturbing ways. We see coerced or false confessions to have young people admit to things which may or may not be true. And finally, we see what may be most pernicious, which is a lasting negative impact for youth, their families, and their communities about interacting with law enforcement or even asking law enforcement to assist in problematic situations. So for those reasons, we tried to bridge the gaps in policing, in police-youth interactions by developing 12 model policies. I am going to make sure that you can find, oh yes, thank you, Tina, for already posting it. You can find those policies through the link in the chat. We're going to make them available to you a couple of times during this presentation. This is the first of its kind set of policies that Shelley led the effort on. They are comprehensive, and I say that, and yet we keep hearing other angles we should have considered and included. These policies are extensively researched, vetted by an array of experts from public defenders to prosecutors, to juvenile court judges, to police misconduct attorneys, to folks running youth programs, and to law enforcement. We have used extensive legal authority in developing these policies, and they have been created for law enforcement agencies, some of which you may be working with, to adopt and adapt to state law or to the particular issues your law enforcement agency may be looking into. We also think that state legislatures, which often act when law enforcement agencies won't, can consider making these model policies available or requiring the implementation of policies, and that executive offices of public safety may want to issue such model policies for their state as a model of what law enforcement agencies across their state should adopt. For community members like you, we also hope that it's a roadmap for reform where there have been issues in police treatment of youth or in understanding how police and youth are permitted to interact according to state laws and law enforcement agencies' perceptions. A policy for this reason is something we view as a contract between the law enforcement agency and the community that allows predictability in what those interactions might look like. Policies, help law enforcement agencies meet public expectations for youth policing. And if they are published, as we recommend all policies be, they can be very helpful in warning youth of what to expect, warning parents what to expect, as well as helping make it clear what may happen if you do not adhere to those expectations. But the problem is most Americans think that law enforcement agencies already have policies for youth and or training for youth, when in fact, as I've mentioned, they don't. And this is the result of a survey we conducted in early 2023, which showed that about 22% thought most law enforcement agencies did, and some probably did, bring us up to 56%, when in fact it's closer to less than 5% probably across the board that give a comprehensive set of policies to guide their officers from initial interactions and investigatory stops with youth to other matters going through arrest processes and interrogation. You may ask yourself, how can civilian oversight help address issues in youth policing? Well, we think it's the same way that you're doing now with adult issues. We think these policies can help you take a closer look at recurring issues involving law enforcement. Maybe some of these are the source of complaints. Maybe some of these are the source of dismissals in court, in juvenile court, or decisions by prosecutors not to advance cases. Either way, we believe that it is really key when you want to learn about these youth policies to understand the key legal principles that need to apply and may not be applied to youth currently in your jurisdiction. It's important to understand why being a youth requires a different approach in policing and responses, and what the right questions are and how to ask them of your law enforcement agency. Finally, we believe these policies can be very useful for you when you want to advocate for policy and practice reforms of your law enforcement agency. I'm going to share the screen now with Shelley, who's going to talk about some of the legal bases for ensuring youth rights are protected during typical interactions with law enforcement.
Thank you, Lisa. So in the time that we have together this afternoon, we thought we would focus on 3 interactions. The first, investigatory stops, non-custodial interviews, and search and seizure with youth, things that happen sort of on the street in the spur of the moment. Secondly, Miranda warnings, waiver of rights in youth interrogations, and third, use of force with youth. And in each of these areas, we'll provide sort of a high-level overview of important legal principles. We'll explain why these law enforcement encounters are different for youth, and we'll describe how strategies for youth model law enforcement policies address the issue. So next slide. So first, what does the Constitution say about investigatory stops? And I'm not going to read this word for word, but this is the text of the Fourth Amendment, which essentially deals with searches and seizures and what you need in order to do that. And in the course of an investigatory stop, that is a type of seizure. So next slide, Lisa, please. So some key legal principles. An officer can stop somebody on the street for what's called an investigatory stop. The officer doesn't need a warrant, but what they do need is reasonable articulable suspicion of criminal activity. And reasonable articulable suspicion requires at least a minimum level of objective justification for making the stop. And the officer has to have more than a hunch, more than an unparticularized suspicion. And there you'll see at the bottom two major cases from the Supreme Court that give us these principles: Illinois versus Wardlow from 2000 and Terry versus Ohio from 1968. So why are investigatory stops different for youth? Why does that require a different approach? Well, the first thing is an officer comes up to me on the street and says, "Excuse me, ma'am, I would like to ask you about something." I'm probably going to stop. 14-year-old me may not have stopped. Youth may not immediately comply with officer directives. They might run, they might verbally challenge the officer, they might freeze, or they might fail to respond. And the reason that they do this is because stress, fear, and anger undermine their capacity to control their responses. Remember what Lisa said, their brains are in construction, they're under development, and they think they know things that they don't really know. And all of that means that when that officer says, "Hey, kid, let me ask you about this," they might just take off. So then we get to the issue of what's called consent searches and some key legal principles there. So if an officer comes up to you on the street and he's asking you if you know anything about, the break-in in the bodega next door, and says, "Do you mind if I look in your bag?" If you voluntarily consent to that, the search doesn't violate the Fourth Amendment, but it has to be truly voluntary. And in order to determine that, we look at what, famous or oft used legal phrase, the totality of all the circumstances. And these include the person who's being asked, their age, their education, their intelligence, their experience with the law, and the context in which their consent was given. So you can see how these factors are really different when we're talking about a young person. Next slide. Some youth may just be incapable of giving their valid consent due to those factors. They're too young, they don't understand what's going on, maybe it's creating a trauma response. And so they're saying yes, but they're not really able to give their valid consent. And quote here from a Georgetown law professor on the next part of this slide: "Youth who don't know their rights and have always been taught to obey, the request isn't a 'would you mind?' The request sounds like a demand." So our model policy number 2 tries to address some of these issues. The policy provides detailed guidance on stops, interviews, pat down for weapons, and consent searches, guiding the officers through each of these interactions and how they should approach it when they're dealing with a youth. The policy describes to officers why this has to be different for youth, some of the things that we were just talking about. And the policy addresses alternatives to arrest. As Lisa said several slides ago, sometimes punishment isn't the answer. Alternatives better meet the kids' needs and their community needs. And so this policy talks about the value of alternatives to arrest. So next, we get to the issue of Miranda and youth interrogation. And so here we have the language of the Fifth Amendment to the Constitution, probably something we're all very familiar with, the concept of taking the fifth. But as I was preparing today, I realized that it should have also included the 14th Amendment, which talks about the fact that you can't be deprived of your life, of your liberty, or your property without due process of law, and that you can't be denied equal protection of the law. And so when you're faced with incarceration, that's a deprivation of your liberty. Next slide. So, any of us who've ever watched an episode of Law and Order, or any other movie involving police or cops or courts, we're familiar with Miranda, the 1966 case issued by the Supreme Court. And there on this slide is, I don't know if they still carry them, but in the, analog days, officers would often carry cards with Miranda warnings so they could get this language right when they read it to individuals that they were taking into custody. And those rights apply to youth too. In 1967, Supreme Court decided a case called In Re Gault, and the court said youth facing delinquency proceedings must be afforded due process, including the right against self-incrimination and the right to counsel. Some key principles in youth interrogation. You're entitled to a Miranda warning when you're in custody. So what does that mean when we're talking about a young person? In 2011, in JDB versus North Carolina, the Supreme Court said that you have to see this in the context of the youth's age and the other circumstances in the interrogation. JDB involved a middle schooler who was called into the principal's office and interrogated for a series of break-ins and was never Mirandized. And the Supreme Court said that that was wrong, that that the officer knew he was a middle schooler and should have taken that into account, because the police said he wasn't Mirandized because there was no expectation that he was in custody. But the court said, no, JDB saw it differently. So the key question here is, would a reasonable youth have felt free to end the interrogation and leave? You're 14, you're in the principal's office with a police officer, the door is closed, maybe the police officer is saying, just come clean, Shelley, we know that you stole it. Would you feel free to leave the interrogation? Probably not. So, as with adults, when we get to the issue of waiver, right? People can waive their rights. No, I want to talk to you, even though I don't have to. No, I know I need a lawyer, but I'm waiving my right to a lawyer. So, as with adults, when you're in that interrogation room with a young person, the court is going to look into all of the circumstances that surround the interrogation. And for youth, these circumstances include the youth's age, experience, education, background, and intelligence, and whether the youth has the capacity to understand the warnings given him, the nature of his Fifth Amendment rights, and the consequences of waiving those rights. This language coming from a Supreme Court case issued in 1979, Thurau versus Michael C. So when we get to interrogations and a waiver of rights, why does being a youth require a different approach? A number of reasons. The first is, going back to the 14-year-old in the principal's office, sometimes a youth who's in custody will feel pressured to submit to questioning when a reasonable adult will feel free to go. Why? They're a kid. They don't know what's going on. They're intimidated. And perhaps they think if they just say what they think the officer wants to hear, they can go home. They can get out of that room. For these reasons, youth are often more likely to make false confessions. They didn't do it, but in the pressure of the interrogation room, they just admit to things that they didn't do. Maybe they don't understand the way the questions were put to them. And on that end, youth may also be particularly subject to coercive tactics during interrogation. Again, I'm a fan of Law and Order, and you've probably seen many an episode where one of the detectives tells the suspect, the blood test came back and it's your type, or we found your fingerprints on the weapon. A lot of times that's not necessarily true. And in general, officers are allowed to use those types of coercive and deceptive tactics with adults. but there's a good argument why you shouldn't use them with kids, because a kid will break in a way that an officer wouldn't. A couple of other things to think about here is, especially with respect to waiver, you have a right to an attorney, but depending on the workload of the public defender office, depending on when we can get in touch with their attorney, a youth could be sitting there in the interrogation room for a long time, waiting for a lawyer to show up. A youth might be alone in the interrogation room with just mom or dad and no lawyer. And maybe mom or dad is thinking, I can't afford this. I have to get back to work. And I do want my kid to own up to what they did. And youth and parents sometimes waive the youth's right to counsel without ever speaking to an attorney. So all of these factors leave youth susceptible to pressures and to making false statements, even when an adult would not. We also know from research that youth react differently to interrogations. A youth's developmental stage, experience, and other factors may mean that they don't really understand the Miranda warnings. We're used to seeing it on television. They may not. And there's, in fact, some surveys indicating that even when people try to write simplified Miranda warnings for youth, kids still don't understand the words, and they don't understand the consequence of waiving their rights. So our model policy number 4 tries to address a number of these issues. The policy provides detailed guidance on key decisions and steps in the process. Like policy number 2, we try to walk the officers through, what do you say in the interrogation? What do you say to the kid? What do you say to the parents? What's the role of the attorney? We try to incorporate the science about youth understanding of Miranda and about interrogation. And our policy is informed by court rulings, JDB probably being the most important one, and also some recent important changes in state law, such as state law changes outlawing deception or coercion in interrogation, and state law changes aimed at making access to a lawyer easier. So last, we're going to go to the area of use of force and some key legal principles here. Before we talked about investigatory stops, I put up the language of the Fourth Amendment, which talks about unreasonable searches and seizures. Unreasonable seizures includes the use of excessive or unreasonable force. And once again, that is so often in the law, there's a balancing test, right? Did the officer use unreasonable force? A court is going to balance what were the individual's Fourth Amendment interests and what were the governmental interests at stake in the encounter. Graham versus Connor, which is Supreme Court decided in 1989, that's a case in general about use of force. It's not specifically about kids. But again, being a youth requires a different approach, because in an examination of the totality of the circumstances, when we're balancing different factors, age and youth development can be a factor. What was the kid doing? What did they understand? What provocation did they give the officer? Their age and their development is relevant to that. And something we've touched on now several times, their immaturity, their difficulty in thinking through the consequences and controlling themselves. When they escalate and an untrained officer reacts, the whole thing escalates and risks really bad and often tragic outcomes. Youth also, for physiological reasons, sometimes experience certain forms of force differently. Sometimes force is dangerous for youth because they are developmentally immature. And on the right-hand side of the slide here, you see a picture. This is a 11-year-old girl, and which I hope you can see it. What's in the middle of her back there is a taser. She was shot by a taser by an officer who thought that she had shoplifted, and he didn't issue a warning before he deployed the taser, and the girl was unarmed. And one account said that the jolt of the taser knocked this 90-pound girl to a concrete parking lot with her body convulsing. In 2022, Strategies for Youth issued a publication called Catch and Stun, which talks specifically about the danger of taser use on youth, and it's available on our website. So the other thing is that research has told us that youth who are subjected to force or who witness it, or even sometimes who just hear about it in their communities, can suffer long-term trauma and psychological distress. Another way in which this experience is different for youth. So our policy number 5, use of force with youth, addresses some of these issues. Again, a step-by-step approach, talking to officers about developmentally appropriate, trauma-informed tactics to avoid escalating those situations and to bring them down when they do escalate. The policy advises officers to use the least amount of force necessary in these encounters. And the policy includes standards of use and restricted use on specific restraints, weapons, and force. So specifically, what about brandishing your weapon? What about the taser? What about handcuffs? The policy goes through some of the frequently used forms of force and gives officers some guidance about how to deal with you. So finally, we wanted to address an issue that is reflected throughout our policies and throughout the juvenile system, as you all may know. And those are ongoing disparities in policing of youth. We have national data about racial disparities in youth arrest rates. We have some investigative findings by the US Department of Justice about systemic racial disparities in some police departments' stops, arrests, and use of force. And recently, in California, because they have a state law that requires the collection and reporting of data on pedestrian and vehicular stops, we have statewide data from a report issued just in January of this year about disproportionate stops of Black youth, racial and ethnic disparities in police searches of youth, and racial and disability disparities in police use of force with youth. So I think that, my last slide here is we also try to address these issues in 3 policies that you see here. Number 6, about fair and impartial policing on the basis of race, national origin, and immigration status. Policy 7, fair and impartial policing of LGBTQ plus youth. And policy 8, policing of kids with disabilities, kids in mental health crisis, or those impaired by drugs or alcohol. These are groups of youth who are particularly vulnerable in police interactions. The policies talk about those vulnerabilities. They explain the role of federal statutes, for example, the Americans with Disabilities Act of 1990, which applies in police interactions with youth. And these policies provide detailed guidance on equitable interactions with these vulnerable populations. So now I'm going to turn it back over to Lisa to talk a little bit more about our policies and how they can be a resource for your civilian oversight activities.
Thank you, Shelley. We feel that the model policies we've described and developed so far are useful as a template for questions or questioning law enforcement agencies to see whether or not the distinction necessary according to the Supreme Court in science between adults and youth is being made in their practices. And if they aren't, we think that the policies are one step towards curing that and should be integrated with training. Do your policies or practices treat youth differently? That's a fair question to ask a law enforcement agency leader and ask them to show if and how they are doing so. And as you can see from our description of use of force, it can be especially important during use of force. If there are claims that youth are being treated differently, it's good to know how and when, because if the agency you're working with is already doing that, then it's easier to replicate what is accomplished into other situations that also require a different approach by law enforcement and enable youth to be understood as having unique vulnerabilities, especially in stressful situations when they're anxious. And I like to raise this point a lot because for years, we would see a police chief after a really unfortunate use of force on a youth, including some lethal uses of force, saying, well, our officers followed policy. And if you look to see which policy they were following, it wasn't for a 12-year-old child. It wasn't for a 14-year-old. It was for an adult. And so chiefs could say, yes, they followed the policy, but they were not following a policy that was created with a youth's capacity, maturity, typical behaviors, frankly, in mind. If these kinds of policies do not exist, it's fair to ask why and to offer models of what could be included. If policies had been in place, could your agency have avoided negative outcomes? And you might want to look at particular recent cases or complaints that have come into the agencies as a way of analyzing that. For instance, I'd like to point to this 10-year-old arrested for public urination. For sure, adults are told not to urinate in public. I'm sorry, with the technology today. But the likelihood that a child or even an adult would be arrested is typically rare. And here, in this case, the lawyer says that instead of being given the opportunity to stop urinating, the youth was arrested, put in a car, handcuffed, and brought to a police station. And frankly, we don't know how much this happens because data collection of law enforcement agencies does not always document such matters in adequate detail or at all. So one of the policies we recommend is ensuring that law enforcement agencies use accurate and effective record management systems when they are documenting what they've done with youth. Civilian oversight of youth policing can be a very useful way, proactively or reactively, to address concerns. And there's certain jurisdictions in the United States where the same issues seem to keep coming up repeatedly. And sometimes a policy change that's fully disclosed to the public and the public is invited to consider and speak about, so that the law enforcement agency recognizes the depth of the concern, can be a very helpful way of addressing this. It can also maintain or retain community trust and legitimacy. In fact, it is critical, we would say, to ensuring the sustainability of trust and legitimacy. And for those of you who've been in such communities, you know that if an officer harms, especially lethally, a youth, it's a hard fact to get beyond, and it is a reputation that can really harm an agency for a long time. The other values of the civilian oversight, considering and recommending the use of policies, is it helps officers and law enforcement agencies be held accountable, and be held accountable according to objective, explicitly public standards and policies that everyone can read and everyone can see. And this is really important because in our experience, the lack of uniform response in law enforcement agencies to kids for various reasons, including law enforcement officers' characteristics and kids' characteristics, not to mention the circumstances in which the two encounter each other, are enormous. So it can help promote uniformity and ensure that uniformity is maintained by ensuring it is something that officers are held accountable to. It also provides a basis for state level advocacy. And we say this because we know that not all law enforcement agencies will consider these policies, even though it could often help them avoid what they like to call as exposure or liability in lawsuits. But state peace officers, standards and trainings, commissions, accreditation agencies in states, as well as legislators and legislatures, are otherwise available to try and ensure that these policies and standards are adopted at the local level. You may say, well, how am I supposed to know if a law enforcement agency has youth-specific policies? There's an easy way to do it if you are working with an agency that publishes its policies, and increasingly more do. In California, most agencies put their policies online, and all you have to do is type in the word juvenile to look up what is likely to be covered. And typically the word juvenile has to do with the situation in which a youth is being charged with an offense for regarding to delinquency. And you can very quickly see what topics are being covered. Is it the stop? Is it how to handle an investigatory stop or how to ask for consent of a 12-year-old? What kind of processes are in place? What steps should a law enforcement officer follow? And who is going to supervise how that law enforcement officer followed those steps? If you search for these youth-specific terms, and juvenile is the most typical, you can look for youth or child, you are going to see how much of the policies are even considering issues that law enforcement and youth interact about or not. And you can use strategies for youth policies to see if and how important these policing issues are addressed. For instance, one of the unique policies and unique to youth is what is a law enforcement officer going to do when they encounter a child during the execution of a residential search warrant? How is that child treated? Are they subject to gunpoint or not? So those are really key issues because those are situations in which youth are often totally bystanders, but can be really seriously impacted. We are standing by, and of course we'll be on the next part of the call to answer your questions, but we want you and invite you to look at our website. You can use this QR code here to find it, or thank you again, Tina, for putting the link into the chat. Not only do you see policies, but you see really extensive appendices. This is something Shelley led again, and they are really comprehensive descriptions of the social science basis of which we've used to make these assertions and beliefs, but they also refer to the number of cases that have resulted from law enforcement agencies or officers not considering, the unique issues that youth come in to or experience as a result of a lack of officers' policies. We also thought that if you look at our model policies, you could see the poll results on public support and expectations for law enforcement agency policies. This is something we conducted in early 2023, and the answers are rather interesting, and they align with what a lot of our experience in the field shows, which is folks really want to be sure that when a law enforcement officer encounters a vulnerable youth, for instance, a youth having a mental health crisis, they know how to encounter them, they know what to do, and they don't escalate that interaction into something worse. And finally, you can see more on the need for and benefits of law enforcement agencies and youth policies on that part of the site. You can also read some of the interviews and coverage of the policies, including the way the policies are being published by Juvenile Justice Update and Shelley's interviews on the imprint and the COPS office podcast regarding the importance of policies when supporting officers to interact effectively with young people. So we look forward to speaking with you in the next phase of this conversation. And here's our phone number and our email addresses. Please contact us if you have any question or you would like support in working with the law enforcement agency to consider these policies. Thank you.
Thank you, Lisa and Shelley. We've got a couple questions and we've got about 9 minutes, so we can get to at least some of them. So I'm going to read the questions out loud for the benefit of people who will be watching the recording and aren't here today. They won't be able to see the questions that were posted in the Q&A, so I will read the first one or each one before you answer them. So one question: do youth in a school setting dealing with a school resource officer lose any of the rights they would normally have on the street when dealing with a patrol officer?
I will take a swing at this one. And it's a little complicated because at least at the Supreme Court level, most of the cases have been about youth and their rights in school vis-a-vis school officials. So there was a case about did the assistant principal need a warrant to search the middle schooler's bag? And essentially what the court has said with respect to school officials is that kids do have Fourth Amendment rights in those situations, but they don't have the full panoply of rights that they would if they were on the street. To my knowledge, I don't think there's been a Supreme Court case dealing squarely with a school resource officer in a school. But when I was at the Department of Justice, I was involved in a case in Kentucky where a sheriff's deputy used force on two very young children with disabilities, the third and fourth graders. And the court there analyzed the facts and thought that the officer used excessive force. And as I recall, the court just applied that Graham versus Connor, the seminal Supreme Court case on unreasonable force, to that situation. So I think you would go into it with the assumption, particularly when we're talking about a school resource officer in their law enforcement capacity, if he's a sworn officer, if he works for the sheriff's department and he's called to the school and that's his beat, then what I would argue is that the kid has the full panoply of their rights in those interactions, and that their rights are stronger there than if we're talking about the assistant principal.
I would just like to add that from what I've seen, the school situation is full of pitfalls. For instance, school resource officers may be standing in the office with the school principal. The school resource officer may not be questioning the youth, but the principal is, and everything the school resource officer hears in the questioning is then used to arrest the youth. And that seems to me unconstitutional, but it is very prevalent. And not all law enforcement officers who are working as school resource officers will agree to do this. I also think that just the nature of the school situation and fear of guns, fear of drugs, fear leads to an escalation of fear in some situations by SROs and encourages them to take actions in a way that may not happen out on the street. So it's a complicated situation, and I would add that it changes dramatically by region.
I just add, we try to address many of these questions in our policy number 10, which deals specifically with encounters with students, and try to go through the different permutations. The officer who is called in from the sheriff's department, the officer, some school districts have their own police force, or maybe you have an officer who, is just brought in because something happened. And we try to address all of these and apply some of these principles to those situations. Also, I was talking about Miranda and interrogation, and when would a youth reasonably feel that they were free to leave. And not the Supreme Court case, but some of the cases that have interpreted that decision deal with just that type of situation. The system principal is doing the questioning, but the door is closed and there's a police officer there. Does the youth really feel that they can leave in that situation?
Okay, next question. Do you have guidance regarding legal and ethical implementation of youth curfews? Our city is considering a curfew policy amid widespread concerns about profiling and discrimination.
We didn't include those in our set of policies. This is a highly contentious subject. We've seen very big differences even across the circuits in how they uphold or not. We could probably find research for you and suggest how other states and particular jurisdictions have dealt with it. It seems to be the Plan A response of any law enforcement agency or community that feels the youth are out too late and getting involved in behaviors that are problematic and is specifically violent.
Try to get another one. Let's see, there are a few more. How can police academies integrate youth-specific de-escalation training into their curriculum? And are there existing models or programs that can serve as effective resources for this purpose?
Well, I'll answer the first part of that question. There is only one thing stopping the adoption of training in youth, in police academies in the United States, law enforcement academies, and that is political will. Until we have strong enough political will insisting that law enforcement academies must train officers how to work with youth, how to communicate, how to understand the developmental differences, and then adjust responses to them accordingly, we're not going to see any change. It is solely political will. We know that when there is political will, particular topics are added to the academy curriculum and to continuing education of law enforcement officers curriculum. But we're not seeing that political will. And so I saw someone asked, what can I do if I'm running a youth organization? Well, you can help organize around that, especially if you've seen interactions that have not been helpful, but in fact harmful to youth. And so there's that. There are many groups that are now talking about training in de-escalation. They are primarily for adults. We offer training called Policing the Teen Brain and Policing the Teen Brain in School trainings, which focus a lot on how to avoid escalation, so you don't need to necessarily de-escalate. A lot of law enforcement training academies are training folks in de-escalation skills that ought to work with everybody, but don't always work with youth. And so it's unfortunate that they can't even focus just some of the time on what would work better with the youth. So there's that. I'm sure that if you go to the International Association of Chiefs of Police, you might find some model programs, and same thing with the International Association of Directors of Law Enforcement Standards and Training. This is an organization that also certifies some training and not others.
And one more, I know we're at 3 o'clock, but one more, because I think this might be a quick one you can respond to. thank you for this presentation. It's informational. Will there be a policy added for how police should interact with youth as it relates to sexting / human trafficking and porn being sent through text when both victim and offender are both youth? A lot of school resource officers are dealing with this now.
Well, actually, I thought you were going in one direction and you're going in another. So that it's actually a matter for law and state statute to decide how to deal with youth who are sexting each other. I thought you were going to talk about issues regarding law enforcement sexting and texting with kids, because that has really gotten into the public eye as a major problem. But we can discuss that later too, if you'd like. And yes, we're going to make a policy for that one.
Okay, and so apologies that we didn't get to some of the other questions. There were a few other, I've copied them, and when we get into the discussion room, if the people who pose those are in the room, we will take those. And for anybody who would like to join the post-webinar discussion, I am right now going to put the Zoom link in the chat. Give me a few moments. All right, placing it in the chat now. Please know as soon as you click the link that I'm posting, you're going to be logged off of this webinar, and then you'll be in the waiting room for the discussion. And I'm going to hang out here just to ensure that whoever has the link and wants to join the discussion has the time to copy and paste or click it. And then once I am sure that everyone who wants to attend is able to, I will end this webinar and then I will start the discussion room. So just hang on with us if you're joining us in the discussion and you're in the waiting room. Okay, so it is posted. All right. And I definitely want to make sure our presenters get there, get to the Zoom room before I do. Just a couple of announcements before I end this webinar link and then go to the Zoom room. There will be a follow-up email within 5 business days of today, where any attendee will have the link to the recording and then also a link to the PowerPoint presentation slides that were used today. Our next webinar is April the 25th, Understanding Civilian Oversight's Fast-Changing Legal Landscape. And then the call for proposals for the conference is open, and the deadline to submit a proposal is April the 11th. So thank everybody in the audience who joined us today, and hope to see some of you in the discussion room. And thank you, Lisa and Shelley, for sharing your expertise and knowledge and your time today. And we hope that everyone found something of use who is attending today. So the link is in the chat. I will hold on to make sure that you two are able to
Thank you.
and get over there, and everyone just wait for me and I'll be there soon. Thank you, everyone. Have a great weekend.